So do courts remove statewide measures from the California ballot? Well, the answer is yes. In fact, the judicial branch has done so recently in three instances. The most recent example was in 2024 when the qualified measure for the statewide ballot, called the California Two-Thirds Legislative Vote and Voter Approval for New or Increased Taxes Initiative, was removed by the California Supreme Court. It had ruled that the proposed measure amounted to an impermissible revision rather than an amendment of the state constitution, and therefore it could not go before the voters. So this measure was prevented from being placed on the ballot despite having obtained the requisite number of voter signatures to qualify for the ballot. In 2018, the California Supreme Court removed a measure from the statewide ballot. It was Prop 9, called the Three States Initiative. This measure was removed because the court determined that the potential harm in permitting the measure to remain on the ballot outweighs the potential harm in delaying the proposition to a future election. And in 2014, the California Supreme Court removed Proposition 49 from the November 2014 ballot. This measure came about from SB 1272 Ted Lieu, which was allowed to become law without Governor Jerry Brown's signature. Prop 49 had called for an advisory vote on whether the United States Congress and the California legislature should approve an amendment to the U.S. Constitution overturning the U.S. Supreme Court decision in Citizens United versus the FEC. So this was a measure that the legislature had attempted to place on the ballot and had gotten more than the requisite number of signatures to place that advisory measure on the ballot, but the court precluded it from doing so.